tax-deferred accounts, definitely beneficiary designations on tax-deferred accounts. We want to be able to see your heirs be able to roll over those assets and take advantage of those tax savings of being able to roll things over. If we have to have it in a state, a lot of times it's getting cashed out in one lump sum, and there's going to be a lot of income realized right at the beginning, which isn't necessarily going to be the most beneficial to the children. If they can roll it over and take it out at a longer period of time, there's not going to be as much income tax usually on that. Of course, there's always exception to every rule, and it depends on the children's income level and whatnot. But usually, and of course they have to make that election. They can always elect to take it in one lump sum and pay the tax up front, and that certainly does happen. So, that's always something to consider. Household goods, personal property. That's always going to be usually left within the family to make those decisions. That usually they can work it out. We have people. Maybe if you this is Tina's story, so I'll tell you Tina's story. She had a family fighting over a ring. Because you need to make sure your descriptions are good. No, that wasn't the diamond ring that Grandma really left me. She really wanted me to be left with this diamond ring. Grandma was buried with that diamond ring. They actually had the body exhumed in order to get that diamond ring. So, it's very important on your list. We can do personal property through a written list that is signed and dated. It doesn't have to be anything fancy. You don't have to go to a lawyer every time you change your mind. But it is important to be very detailed. In fact, I've seen increasingly people using their digital cameras to make their personal property list. And it comes into our office fairly frequently that they've taken the picture and they put the person's name by it in order to not have any confusion. Other people, a lot of people I hear use the Post-it note method. Of course, that's not any sort of, I don't think, legal method that I can submit all your Post-it notes to the court, but But I hear it all the time, that people, But a lot of times we do actually see people distributing their personal property, the really meaningful things, prior to when they pass away, because they'd rather see the joy of giving it to their loved ones prior to them passing away. And if you're moving into a smaller condo or assisted living or something, a lot of times those things kind of happen more naturally. So a lot of times there's not necessarily huge fights over personal property, but we do get into bidding between families on things. They're more sentimental values than there really typically are cash value. Typically, people are a little surprised when we get valuations on some of the collections that people have and whatnot. What the actual retail market is for them, if you were to actually sell them, is unfortunately usually a very fraction of the amount that you actually paid for them. So it's hard to sell them. I mean, there's not really, a big market for a lot of those types of things. So they're mostly sentimental value that we're dealing with there. So we try not to get involved as lawyers because we don't really want to have to incur fees for, usually the fees are going to outweigh the actual value of what we're fighting over. So we try to encourage people to work it out amongst themselves as much as possible. But it doesn't always work. So once we have kind of a picture of what your assets are, then we start to talk about what you want to happen with those assets. And one of the big questions that we ask people that when they come in to talk to us is, what happens if you're incapacitated? And that's something that not a lot of people are thinking about when they come in to do their estate plans. They're thinking about, what happens to my assets when I pass away? But I present them with a big question. It matters more to you what happens to your assets and who's going to help you manage them when you're not able to anymore. So we're seeing the situation where mom and dad move to the nursing home, and then they need a little bit of help paying the bills, getting to their doctor's appointment, just talking to people on the phone as far as medical care go, or contracts, setting things up and things like that. So that's the incapacity side. that we talk about. So that's when we're talking about powers of attorney or a trustee in the trust. Who's going to be the trustee and who's going to really manage those? Because that's a really big position that you're putting somebody in. And unfortunately, more and more, you're probably seeing in the paper too, the stories about the elder abuse that's taking place. And unfortunately, it's all too common where that happens. So it's important to make sure you have a good, trustworthy person who's going to make those decisions and help you out. And then, of course, there's going to be the question of what's going to happen to the assets after you pass away. And we try to, as much as we possible, take into consideration what might happen to your assets if there's going to be changes in valuation. We can't predict the stock market or anything like that, but we try to build in some flexibility as much as we possibly can. And then, of course, we talk with everyone regarding estate taxes. That's a big topic. And a Minnesota estate tax exemption is $1 million. And I hear from a lot of people, oh, I don't have $1 million. I don't need to worry about estate taxes. Minnesota doesn't have an inheritance tax, so people who get your money aren't going to pay tax on their inheritance. But your overall value of your estate is going to be taxed if it's over $1 million. What people don't really think about when they're actually thinking about their wealth is the equity in their home. That's not something you think about. I don't have that cash in my possession. I can't go out and spend that easily. They don't tend to think about the death benefits on their life insurance policies, their 401ks. Those things that you don't think of as liquid assets are all going to count toward that $1 million total.
Is it the entire million, or is the amount that's over $1 million?
The amount that's over the $1 million is taxed. Yep. And Minnesota hits really hard on the first 100,000 over. So they're going to get you at like 38% on the first 100,000, and then it drastically declines from there. So while you're going to pay on 1.1 million, you're going to pay 38.6, on 1.1 million. If you're at 1.5, 1.6, you're going to pay like 50,000. So I mean, you really, 2 million I think is 85, 86. So you really see that they're really getting their money on the first dollars over. So there's some planning that we can do. Minnesota still has that. The federal has had some big changes that Minnesota hasn't adopted yet. So they're not going to get rid of the estate tax anytime soon in Minnesota. We just need the money. And there's not been any talk of it that I've heard about. The federal, I don't know if anybody's familiar with the federal estate tax. We have had the estate tax exemption gradually increasing with the Bush tax cuts, so that in 2010 we had no estate tax. In 2009 we had a $3.5 million exemption. We were scheduled on January 1st of 2011 for the tax cuts to go away, and there to go back to the $1 million exemption at like a 54% tax rate. So on December 17th of 2010, they finally enacted a law that was good until 2012. So we still have very little clear picture as to what overall is going to happen. What they did do was they reinstated the estate tax for 2010 to $5 million, and then that's $5 million stays for 2011 and 2012. So in 2010, people could still elect out of that $5 million exemption and take that big exemption. Why would people do that if they had a huge estate? Because you lose your step up in basis when you do that. When a person dies, you get your basis, what you pay for capital gains, that level that you determine capital gains with, goes up to the date of death value. We lost that when we didn't have any estate tax. So for people whose estates are under $5 million, it's better that they did this because you get that step up in basis. So on farmland that was bought for $100 an acre, now on the date of death it's worth $3,000 an acre, your basis is now $3,000. Now we had some big deaths that actually gave us a little bit publicity in 2010. George Steinbrenner passed away with, I think it was $4 billion estate. We had the founder of Taco Bell pass away, one of the big oil tycoons pass away with $1 billion estates. Depending on their family and what they decided to do, more than likely they're passing on that $5 million and not wanting to pay the estate tax on that. But for most people, we're going to keep the $5 million exemption for 2010. What's going to happen? Oh, a big thing is too that exemption for the federal purposes is now portable, meaning that if one spouse passes away, they use $1 million of their federal estate tax exemption. The surviving spouse can elect to keep that $4 million, increasing their estate tax exemption to $9 million. Unfortunately, Minnesota hasn't followed this, so we're still doing some of our trust tax planning stuff because we haven't had that happen in Minnesota yet. So we're still doing all the same stuff we basically were before because they're not following suit on that. So, one thing Minnesota did do, though, is they are allowing $4 million worth of assets for farms and small businesses to be exempt now. So they did recognize that $1 million estate tax exemption in Minnesota is really hurting hard on the farmers and small business owners, where you're looking at farm property with values $3-4 million, and they're looking at having to sell a piece of property or not being able to keep it in the family in order to pay the estate tax on it. We see that a lot. So there's now some ability to exempt that if they've been actively farming that. So they are giving a little bit of a break. You know, we haven't seen the effects of a lot of this yet. I was meeting with a client on Friday trying to explain some of this to him. The forms aren't even available. First return was due October 1st, but the forms aren't available yet. For Minnesota anyway, the federal ones, I'm not sure if they're final. We got them on Monday. So the legislature did this at the last minute, but the IRS and the agencies, they weren't prepared for it. So they're still trying to figure out how do we do this and how is it really going to work. So really a lot of the wrinkles have to be smoothed out still. So hopefully it won't be too bad. Okay. Does anybody have any questions before we go on? All right, I'm going to go in a little bit more detail about how wills and trusts work then. A will is, like I said before, something that is effective only after you pass away, and it does have to be probated, which typically means paperwork back and forth with the court. We only have to go to court for a hearing if there's some sort of issue, whether there's going to be a contest to the will, or maybe you lost the original, or we can't find one of the heirs for some reason, then we're going to go formally. Typically, we know where the heirs are. That usually happens when it's a family tree that we just can't quite trace back. Usually it's going to be a single individual. And if they've been to our office, we try to get that, when people do their estate plan, we try to get that ahead of time so that we can do that. Otherwise, we're looking at formal probate. But typically, informal paperwork with the court. So it's not, and when we do go to court, typically it's not too big a deal. So we don't typically see an objection unless there's some sort of problem with the will or somebody's going to contest it, and typically we know that ahead of time. So there's not usually a whole lot of surprises in probate court. You don't typically have people dramatically showing up to object.